Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 111. It seems to come around quicker this time, doesn't it? In fact, I missed the usual slot 2 weeks ago, unfortunately. Pressure of work and all that. Overworked and underpaid. That's us partners. Anyway, we've got 3 cases, of course, and I think they're really interesting ones this episode. I thought we'd start with a disability discrimination case dealing with reasonable adjustments. We've then got a restrictive covenants case, which I think is a useful illustration of matters connected with the enforcement of restrictive covenants. Then thirdly, we've the latest gig economy case. I'm going to deal with that relatively briefly, but since this subject is in the news so much these days, I didn't want to let it go past without commenting at least briefly. As usual, please do not forget you can access the podcast via iTunes, Mayor Brown website, YouTube, etc. And the Twitter feed, Nicholas Robertson at Nicholas ROBER11, which is also where we put out the links for the cases that we reference. First up, the Home Office UK Visas and Immigration and Karachi. This is an EAT case dealing with 2 separate matters. The first is an appeal by the employer against the finding that they were guilty of disability discrimination. The second was an appeal by the claimant against the rejection of her claim for race discrimination. The race discrimination claim is of less general interest, so I'm not going to go into that at any length. The background was the claimant started work for the employer in 2006. By 2011, she was a team leader, and she'd also undertaken work as an assistant director for a while. In 2013, she told her line manager about a disability from which she suffered, and that the impact was causing her to work long hours in order to get her work done. The employer looked into this and arranged for specialist equipment and a static desk to be made available to her. She also asked for a flexible working arrangement under which she worked compressed hours, i.e. doing a 36-hour week over 4 rather than 5 days, and this too was signed off by the employer. Her line manager changed at around this time, and the new manager had a meeting with her in May 2013 in which she handed over a dyslexia report. This indicated, obviously, that she was suffering from dyslexia, and the employer accepted at the tribunal hearing that she was disabled, in the eyes of the law, and secondly, that they knew about her disability from the point of that meeting. So, obviously, the preconditions are laid for the question of reasonable adjustments. Things obviously went downhill from 2013 because, notwithstanding the adjustments which the employer had made, the claimant brought proceedings for disability discrimination and, as you know, other claims. Just focusing in this podcast on the disability discrimination, the claimant asserted in her tribunal proceedings the employer had a provision or practice of giving her the same volume of work as her colleagues. This placed her at a substantial disadvantage in comparison with non-disabled colleagues because it took her longer to complete the work because of her dyslexia. Therefore, she was working longer hours to complete the same tasks. She asserted, at the tribunal stage, that a reasonable adjustment would have been to reduce her workload in order to avoid that disadvantage. As I say, we don't know what led factually from the employer making the adjustments that had been requested by the claimant to the claimant putting in the claim to the employment tribunal. Anyway, at the liability hearing, the employment tribunal found against the employer. The Employment Tribunal accepted that there was a requirement that the claimant carry out the same volume of work as her colleagues, and that she had to work extra hours as a result. The Employment Tribunal also recorded the employer accepted that a reduction of work could be a reasonable adjustment. In principle, the Tribunal found this was a reasonable adjustment and should have been made, and it accepted it was common ground the employer hadn't sought to reduce the volume of work that she was undertaking. The employer appealed to the AT, and central to its appeal was the fact that the tribunal had not taken into account that the employer had made the adjustments that were actually requested by the employee back in 2013. The employer also pointed out that neither the dyslexia report nor the claimant had suggested a reduced workload in 2013 when the other adjustments were being discussed directly with her. Well, the AT upheld the Employment Tribunal's view the employer had failed in its duty to make reasonable adjustments. The adjustments offered and put into place by the employer did not remove this disadvantage which she was suffering. VAT accepted that it was already clear law, based on an earlier case called Project Management Institute and Latif, that the claimant did not have to have actually requested the specific reasonable adjustment at any point prior to the tribunal hearing in order to win a tribunal claim. The duty is on the employer, and the employer cannot subcontract the duty to consider and make reasonable adjustments back to the employee. Here, therefore, although they had made the adjustments requested, there was more they could and should have done. I'm sure employers listening will feel this is a harsh decision. Who is better placed to know what adjustments they might need than the employee? Well, the reason I wanted to bring this case into the podcast is not because it changes the law, but because it emphasises what the law actually is at the moment. Here, the employer may well feel aggrieved in general terms, given that it had made the adjustments requested by the claimant. But it was obvious the claimant was still dissatisfied, and the employer was on notice about the impact of this disability on her hours of work. As such, unless the claimant had specifically disclaimed any suggestion that changing her workload would be an adjustment, I think the employer was always going to be in difficulty on the facts as found by the tribunal at the end of the day. That's a decision in the Home Office, UK, Visas and Immigration and Karachi. Next up is Gamatronic UK Limited and Hamilton and Other. This was a High Court case looking at two directors who had allegedly broken their duty of fidelity to their employer by what they'd done prior to leaving to go and join a competitor. The case is an interesting one, partly because it's a full trial in the High Court rather than an interim hearing, but also because it looks at the scope of what is lawful for a director to do by way of a preparatory steps and what is off limits. It also considers in detail the remedies that were being claimed for the alleged breach of those duties. The facts? Well, the facts can be stated relatively briefly. The two directors were employed by Gamatronic UK Limited. The directors between them had 49% of the shares in that company. Gamatronic's holding company had 51%. There was a shareholders' agreement which required the two directors to further the business of Gamatronic by their best efforts and stop them being involved in any competing business. There were similar obligations in the contract of employment, as you'd expect. Things obviously headed south during 2010-2011, because in late 2010 the two directors started seeing another company, as it were, and they had started having conversations with a competitor. The discussions weren't disclosed until more than a year later, when the two directors left Gamatronic to go to the new company. The shares which the directors held in Gamatronic were repurchased from them, and within 2 to 3 months of leaving, both directors were working full-time in the new company. Their old employer, Gamatronic, found out what had happened and alleged that the two directors had been in breach of their contractual duties and their fiduciary duties since late October 2010. They claimed an account of profits made by the two directors, equitable compensation for profits wrongfully obtained by the new employer as a result of the two directors jumping the gun and providing assistance before employment ended at Gamatronic, and they claimed repayment of the salaries the directors had received from Gamatronic from autumn 2010 onwards on the grounds that the directors were in repudiatory breach of their contract by that time. There were two separate stages to this. First of all, the directors were found to have acted in breach of their contractual and fiduciary duties. Their initial action with the competitor, setting up a founders' agreement with them, looking at a business plan, etc., were lawful preparatory steps, so they weren't to breach their obligations to Gamatronic. Although some of the meetings had apparently taken place during ordinary working hours, and they were of course under an obligation to work, devote all their working time to Gamatronic's business, this by itself was not enough to amount to a breach of a contractual or fiduciary obligation, because there was no evidence that those meetings caused the two directors to take their eye off the ball with Gamatronic. However, the court found that after the initial start, things did start to cross the line. So, for example, one of the directors put together a price list for the new company. They made a secret trip to the headquarters of the holding company for the new employer, concealing it from Gamatronic and covering their tracks somewhat. The purchase of shares by them in the new company was done covertly and via nominees, and that gave them an indirect interest in how the new employer was performing before they left. Finally, shortly before the directors left Gamatronic, it became clear that the individuals were engaged to some extent in supporting the new employer's business and helping to make some operational decisions. As such, therefore, directors, they're in breach of their contractual and legal obligations and fiduciary obligations to Gamatronic. And at that point, when the judgment is being read out, you can imagine the Gamatronic side smiling broadly. However, second part of the case looks at what the compensation should be awarded, and here potentially Gamatronic had a bit of a nasty shock. They started off by claiming they should receive equitable compensation from the two directors for the breaches from autumn 2010. But the court disagreed. There was no evidence the directors had failed to carry on working hard for Gamatronic. They'd only spent a tiny amount of their time on the new employer's business, and in 2011, one of the directors was by far and away the most successful generator of new business for Gamatronic. So that claim failed. Well, Gamatronic then tried to argue that since the individuals were in breach of their contract, they should be obliged to pay contractual damages equivalent to their salaries from the point at which they were first in breach, i.e. October 2010. Court didn't agree with that either, largely because there was no evidence that the directors had failed to devote enough time to Gamatronic's business. They'd simply found time to do other things as well that they should have not have been doing. Gamatronic tried to claim they should get compensation equivalent to the salaries the two directors were getting from the new employer for a period, given that it was asserted the two directors had given the new employer a head start. Here, the court didn't accept that the head start existed, and there was no relationship between the amount of salary that Gamatronic was claiming from the two directors and the damages from the alleged breaches. Finally, Gamatronic argued that the settlement agreements which it had entered into with the two directors, under which it had brought their shares, should be rescinded in view of their failure to disclose relevant information. There was a warranty in that agreement that they had disclosed, in effect, all relevant information, and this was untrue. This claim too failed, because that would have meant that in addition to handing back the money, the process of rescission would have logically required shares in Gamatronic UK to be handed back to the two directors. And Gamatronic did not wish to do that. On that basis, simply requiring the refunding of the consideration paid for the shares, but without getting the shares back, was not appropriate. Therefore, overall, although the two directors had been in breach of their obligations for a prolonged period, there was no significant financial remedy available to Gamatronic. As I said at the start of this is obviously an illuminating case. The scope of the director's ability to be involved in preparatory matters is often a point which comes up in practice, so this case offers useful, albeit fact-specific, guidance. But equally, it's a reminder that establishing a breach of duty is only ever part of the issue. It's the first step. Here, the directors were in breach, but there was no significant financial loss, and therefore there was no significant financial award that was payable. It's one of the reasons why employers will often put restricted covenants into contracts, designed to prevent a seamless transfer of employees and directors from one business to a competitor's business. Well, that's the case of Gamatronic UK Limited, Hamilton and another. Third and final case, Pimlico Plumbers Limited, Charlie Mullins and Gary Smith. And I can promise you there will be no terrible plumbing puns at any point in this short account of matters. I think I've learnt my lesson. Well, this is the latest case on whether an individual is an employee or a worker, in the face of documentation which apparently tried to ensure the individual was fully self-employed and was neither employee nor worker. One of the entertaining bits about the case is that one of the Court of Appeal judges was at pains to say there was nothing of particular interest in this case. The judge said that employment lawyers, quote, should be careful about trying to draw any very general conclusions, unquote, from the case. Still, let us fools rush in where angels fear to tread. The legal issue is that individuals, whilst working for others, may fall into one of three separate categories. You can be an employee, legally defined under Section 230 of the Employment Rights Act as being someone who has, quote, entered into or works under, or where the employment has ceased, worked under, a contract of employment, unquote. A worker, on the other hand, is an individual who has entered into or works under the contract of employment or any other contract, express or implied, and if express, whether oral or in writing, whereby the individual undertakes to do or perform in person any work or services for another to the contract, whose status is not by virtue of that contract that of a client or customer of any profession or business undertaking carried on by the individual. On the third hand, and yes, I know that's one too many hands, an individual can be in business on their own account. And obviously the statutory protections decrease as you go from employee to worker to genuinely self-employed. On that basis, you could either be someone employed under a contract of service, an employee, you could be someone who's self-employed carrying on their own professional business undertaking, or you could be someone who is self-employed but provides their services as part of a professional business undertaking carried on by someone else. If you're self-employed carrying on your own profession or business undertaking, then you're probably self-employed for employment purposes. If you're self-employed but providing your services as part of a profession or business carried on by someone else, you're likely to be a worker. In line with the statute definition, this is often referred to as a Lim B worker. And in case you're wondering what a Lim A worker is, that's someone who works under a contract of employment. All employees are workers, not all workers are employees. Facts. Well, Mr. Smith worked for Pimlico for 6 years. He had a heart attack in January 2011 and then alleged that he was unfairly or wrongfully dismissed in May 2011. He'd signed a contract back in 2005 which brilliantly ambiguously described him as a, quote, subcontracted employee. There was also a manual of procedures and working practices in place at that point, which put him under an obligation to work a 5-day week for a minimum of 40 hours. The 2005 agreement was then replaced by a longer agreement in 2009, which was rather clearer on the status of Mr. Smith and his colleagues. He was going to invoice Pimlico for his services on the basis he would get 50% of the fees charged by the company. He had to account for his own income tax, VAT, etc. He could provide his own materials when he was working for Pimlico, and he would then be entitled to a 20% trade markup on those materials. He was responsible for all expenses incurred by him providing the services, and he had to have insurance. There were extensive restrictive covenants which prohibited from working in the plumbing business for 12 months after ceasing to work for Pimlico. It was, of course, expressly stated in that document that he was an independent contractor. Well, the tribunal found a number of interesting additional facts. He was entitled to reject jobs that were offered to him. He could decide his own working hours. There was no obligation on Pimlico to provide him with work on any particular day, and if they didn't provide him with work, he didn't get paid. He could choose the price to negotiate with the client. He was unsupervised when it came to carrying out the work. He could choose to involve any colleague to help, and he also accepted that he believed he was self-employed at the time and engaged an accountant and filed tax returns on that basis. Interestingly, he also spent substantial sums on materials which he used in connection with this work. In the last full year of working for Pimlico, he spent more than £50,000, that's £50,000, on materials on which he was entitled to a trade markup. The tribunal claim covered unfair dismissal, wrongful dismissal, entitlement to pay during medical suspension, holiday pay and arrears of pay. He also claimed disability discrimination. A preliminary hearing was held to determine whether he was an employee, a worker, or whether he was genuinely self-employed. The tribunal said the claimant was not an employee. There was a clause saying that there was no obligation on the alleged employer, Pimlico, to provide any work, and the claimant did not assert that was an empty clause. In other words, the claimant accepted that was the reality of the situation. Secondly, the tribunal pointed out that it would be inconsistent with the contract of employment for Pimlico not to be obliged to pay the claimant for work done. Here, if a client did not pay Pimlico, then Pimlico was under no obligation to pay the individual. Additionally, the ability to claim the markup on materials which he had sourced personally was also inconsistent with the employment status. However, the tribunal decided that Mr. Smith was a worker within the Lim B test. He was, in their view, obliged personally to work for Pimlico. The 2005 manual had not been completely repealed, and that said he still had to do 40 hours per week, and although there was evidence that work was passed around by the Pimlico plumbers amongst themselves, this is a matter of concession by Pimlico, and the tribunal said it was not a matter of an unfettered contractual right by the plumbers to substitute one of their colleagues in for them at will in any circumstances. The Employment Tribunal also noted that the claimant was under very tight control in most respects, although he had autonomy in relation to the cost for the work he was doing and how he went about doing it. On that basis, the tribunal said that it did have jurisdiction to consider complaints for direct disability discrimination, failure to make reasonable adjustments, and holiday pay, together with authorised deductions from wages. The case went up to the Court of Appeal. In essence, the Court of Appeal accepted that the tribunal was entitled to find that Mr. Smith was a Lim B worker. The contractual documentation was confusing, and so the tribunal had been quite properly able to identify clauses which ran counter to Pimlico's arguments. There was no evidence that he had an unfettered right of substitution, which might have defeated an assertion that there was a duty of personal service. Whilst he was not working 40 hours a week referred to in the manual, that could have been categorised as a limited voluntary concession by Pimlico, rather than a matter of contractual right for him to determine the total number of hours he did in a given week. So, why did I think this case is worth mentioning? Well, I think it's a slightly unusual one. In the past, what we've seen is that the alleged employee or worker is saying that the contractual documentation, which all points one way, is not the whole story. Therefore, the tribunal is invited to look at the facts of what actually happened, rather than the contractual documentation. Here, It was the other way round. The documentation wasn't clear, according to the courts. In the circumstances, Pimlico was saying, look at what happened in practice, but it didn't save him here. Secondly, it was clear that if Mr. Smith was going to be a limby worker, he had to be under a duty to provide personal service. If he's not providing personal service, he's not going to be a worker. Bear in mind that there are two elements to the definition of worker. Firstly, the individual must be obliged to do the work personally. And secondly, and only if that exists, the individual is like to be a worker unless he or she is running their own business. This explains the importance of the finding of fact from the tribunal that there was a degree of substitution genuinely happening, and this was accepted by Pimlico. But it wasn't evidence that there was an unfettered right to substitute his role. However, the most interesting part of the discussion, I think, was what the Court of Appeal had to say about substitution clauses in general and the impact on whether or not someone is a worker. Court of Appeal took the view that the applicable principles in connection with substitution clauses were as follows. 1. An unfettered right to substitute another person to do the work is inconsistent with there being an obligation to accept work personally. 2. A conditional right may or may not be consistent depending on what the conditions are. Obviously, the greater the limitations for the individual seeking to get someone else to do his work, the more likely it is that it is still consistent with the duty of personal service. If the right of substitution operates only if the contractor is unable to do the work rather than simply choosing not to do it, then the substitution right is still consistent with personal service. It's an exception that proves the rule. However, on the other hand, if the individual has a right of substitution, but you have to show that the person he had given the work to was equally well qualified, then that right would be inconsistent with personal performance. In other words, put one of those clauses in, and you may be on your way to defeating a claim for worker status. Of course, bear in mind, the clause mustn't be a sham. It needs to be supported in practice. I do think this guide is going to be very helpful. It's going to allow companies who rely on substitution clauses to try and defeat worker status claims to draft the clauses with the bare minimum restriction in them that is consistent with the obligation to provide high quality services. I think paragraph 84, which contains these comments, is going to be regularly cited where substitution claims are relevant. However, none of this should obscure the fact that this is another case where the courts have found in favour of a claimant that he's a worker rather than genuinely self-employed. So that's the case of Pimlico Plumbers Limited and Charlie Mullins and Gary Smith. So I think it only remains for me to say thank you very much for listening, as always. No employees were harmed or mistreated in the making of this podcast. And I hope we have a good rest of the week. I'm off to watch Bayern Munich play this weekend with my younger son. So instead of the usual report from the cultural frontiers, that is London, I might have a report from whatever culture and sporting matters come up while we're away for a couple of days in Munich. Thanks very much indeed for listening. Bye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances, so please take legal advice if any of the matters discussed are relevant to issues that you are dealing with.